So, welcome back. Here we are, we're in chapter 6, and it's hard to believe that we've just reached the conclusion of our final chapter as it relates to law enforcement. Remember, this is one of the primary components of the criminal justice system, and here we are. We're at the conclusion of it that quick. It's amazing. And then we'll go into our second block or our second primary component of the criminal justice system. But I'll get to that in the end, okay? Just hold on. So to wrap up this block in talking about law enforcement, we want to look at police and the rule of law, because the last chapter, and remember, it was a two-parter. So if you're looking at this lecture and you're like, well, Professor Fields, we're in chapter 6. Well, maybe go back and look at chapter 5, okay? So look at chapter 5, police on the streets, examining organization of law enforcement, the job responsibilities, duties. It's a wonderful, wonderful chapter. It's really probably like 3, 4, 5, 6 weeks worth of material crammed into one chapter. And it was so much that I had to break it down. And if I had more time, I could have even broke it down even further into 3 parts. But we don't have time. So let's look at police and the rule of law, because we understand that if law enforcement are the gatekeepers of the criminal justice system, and law enforcement has the power to take your property, take your freedom, and take your life, well, they can't just operate with unchecked powers, right? We have to have a system of checks and balances, and that's why we have this chapter to close out our block on law enforcement. So let's go ahead and get right in it, shall we? So we know the rule of law. It's a fundamental principle of the criminal justice system. There is an inalienable belief that all government officers pledge to uphold. They pledge to uphold and follow the Constitution. So law enforcement typically interacts with all components of the criminal justice system. Their greatest interaction is, you can split it, because when they take someone to jail, they are interacting with the correction system, but really it's just drop the individual off, make sure that all their paperwork is in order, and then they turn over or they remand the offender to the correctional system. They have a greater interaction, though, with the courts, because as a law enforcement officer, you're constantly going in front of judges for warrants, constantly talking to prosecutors, dealing with those quote-unquote pesky defense attorneys. You're coming to court to testify. So they have a greater interaction with the courts. So law enforcement has to follow the rule of law, because if you get a rogue law enforcement officer, all that means is a law enforcement officer who's operating outside of the law, so they're acting rogue. It's going to create problems as it relates to certain cases. And as I said before, because law enforcement officers are the gatekeepers of the criminal justice system, they are subjected to greater levels greater levels of scrutiny, not only in the media, but through the public. So they have to be on their A game, and they have to operate accordingly as it relates to the law. So when looking at police and the courts, we as citizens have something called due process. Now, there's an amendment that I pointed out in the last chapter. I'm going to get to that in a second. So it might be that I'm jumping out of order, but just bear with me. When we have due process, first of all, the Fifth Amendment grants us the protection against self-incrimination. Have you out there, you that are watching and tuning into these YouTube videos, and maybe you're going to listen and be like, you know what, I like what he's lecturing on. I think I want to follow and see what new videos he puts out, what other topics he lectures on. Have you ever heard of somebody on a crime show saying, I plead the fifth? Hey, did you know that this person over here was engaged in criminal activity? I plead the fifth. Did you see that person over there, batter or strike or do whatever they did? I plead the fifth. Can you tell me what your name is? I plead the fifth. So with that being said, all it's saying is that it protects you against self-incrimination. You are protected under your Fifth Amendment, where you do not have to say anything, and you do not have to essentially incriminate yourself by offering statements. You can say, I'm pleading the fifth. I don't want to answer any questions about it. I don't want to say anything about it. Now, the 14th Amendment guarantees state due process and equal protections, and due process is a key tenet and foundation that is within the laws of our American society, or it's justified by the laws here in America. Due process guarantees that if we are accused of a crime, we have the ability to defend ourselves, and we have a presumption of innocence, which we will get into in later chapters. Now, the procedural due process is applicable to arrest and trial procedures, because what happens is it places limits on police powers, but also it guarantees against double jeopardy and ensures that police arrest procedures are proper, and they are orderly, and they are within the realms of what's acceptable within the government. So in other words, they are statutorily bound. Generally speaking, arrest procedures are somewhat universal, and people who are arrested have a due process. We're going to get to it in just a second. You see it on your screen, but I'm just going to hold off in saying it because we're going to get to it in just a little bit. So recognize that procedural due process is very much applicable to arrests as well as trial procedures. Now, the thing that you just saw was the Miranda warning. And as I told you, I want to make this class a little bit fun. I'm a little bit of a prop guy, right? This is Intro to Criminal Justice. I love lecturing on criminal justice and talking about criminal justice topics. And so I figured each lecture, I'm going to try to mostly come up with some prop. I'm not going to always have a prop, but I'm going to try to mostly come up with some prop. And so here we are. Our prop right here is just what's on your screen, the Miranda warning. Now, this is a Miranda card. I'm going to hold it up. See, you can see it, the Miranda card. And this is one that I received. I am a member of a Gang Investigators Association. And so with that being said, because I'm a member of this Gang Investigators Association, one of the conferences I went to, they always give us little swag bags, goodie bags. And, you don't go to the conferences for the merch. You go to the conferences to learn. And I love learning. I have pages on pages on pages of notes that I've been able to utilize in my lectures. Not to mention, it's still a way that I'm connected to law enforcement, even though I've walked away from that, to lecture and teach and educate you all, the masses. With that being said, this Miranda card was given, and I would keep it in my badge. I was in another law enforcement agency when I joined this agency, but we'll talk about that when we get to corrections. But I just want to read it. And as a law enforcement officer, you're going to typically know this by heart, but even if you know it by heart, you want to be 100% precise in your reading. And this is why I always kept this in my other badge. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney. If you cannot afford one, one will be appointed to you by the court. You can at any time decide not to answer any questions or make any statements. Do you understand your rights? Having those rights in mind, do you wish to speak to me? Miranda card. And the Miranda warning means that you as an accused, you as a potential perpetrator or suspect, you have the right to remain silent. You do not have to talk to law enforcement. If I'm a law enforcement officer, I'm asking you questions, you say, I don't want to talk to you, and I keep asking you questions, I violate this card. I potentially have damaged the case before it got started. Now, if you say, you know what, yeah, I want to talk to you, I want to set the record straight, even though I've Mirandized you, anything you say at that point can and will be used against you in a court of law. So just remember Miranda. For those of you who never knew anything about the criminal justice system, if you're questioned by law enforcement, even if it's during the investigation of a case and you're not 100% sure, and they read Miranda to you, you should probably remain silent just to be safe until you can get your parents or an attorney or somebody on the phone. If they didn't read you Miranda and you start answering questions, if they're a good cop, they're going to say, oh, hold on. I got to read you Miranda. Hold on, let me read you this statement first. Because they know if they start putting in a report and it says I did not read Miranda to the suspect. The suspect did not. The suspect understood Miranda and they waived Miranda. If that's not in a police report, case closed. It's done and it's over. So please understand, you have rights as citizens and as individuals if you come into contact with law enforcement. So what's the difference between probable cause and reasonable suspicion? Probable cause, this is the standard established by criminal law to make an arrest, obtain a warrant, or conduct a search. And when it comes to probable cause, generally speaking, individuals, they feel like they have enough based on evidence that is presented, whether it's seen or evidence that has been, established as such, to make the arrest, obtain a warrant, or conduct a search. Probable cause is very tricky in law enforcement, but it is a great standard in which many arrests, warrants, and searches can be put forth. On the other hand, you have the reasonable suspicion. Now, like probable cause, it's very objective, but it's based on minimal or no evidence. Reasonable suspicion alone may be enough for an officer to effect a traffic stop. Now, again, getting a little bit ahead of myself, but I'm also a former probation officer too. And I remember one time I had an individual, it was reported to me that one of my probationers had a firearm. Now, the individuals said that they saw the firearm, so therefore there was probable cause to assume that the individual had the firearm. However, they could not produce the images to me, so therefore I had to act on reasonable suspicion. So when I went to search the home, try to gain access to the home, try to verify that there was a firearm, I couldn't get access, I couldn't get cooperation. So therefore, I still had to go for a warrant based on reasonable suspicion. And the court granted me because of the credibility that I had with the court. That's the difference. I had very little evidence other than one individual over here who was a counselor who said that this individual had a firearm, and that was it. But I didn't have substantial probable cause. I didn't visually see the firearm. I didn't have a picture of the firearm. I didn't have the probationer posing with the firearm. So I was acting on reasonable suspicion, but the court still granted my warrant because of the danger of, hey, we have a professional saying they saw them with a firearm. So that's the difference when looking at probable cause and reasonable suspicion. And when it comes to traffic stops, a lot of times they may not have probable cause to effect the stop. Reasonable suspicion alone is enough based on the description of a vehicle or, it may fit the description. It's very controversial in some instances, but it is enough under the rule of law. So stop and frisk. Now, stop and frisk is something that I talked about in the last chapter. I believe it was in part 2 when looking at some of the controversial issues surrounding law enforcement. Remember, I talked about how there are there's things like DWB, driving while black, and how minorities are sometimes treated as it relates to law enforcement. Well, stop and frisk is also known as the Terry stop or the field stop, and it was very controversial, and it was highly common in New York City. Now, data, once again, is very old. This data was during COVID and quarantine, so I'd be curious to see if the 2022, 2023 data is out there, or if if this has been updated. But I was alluding to this in the last chapter when looking at the controversy surrounding police interaction with minorities. And I was saying that you don't have to take the word of Professor Fields, who is a man of color, who worked in law enforcement, who has a level of credibility, not just because of what I read in a textbook, not because what I think I heard on some news, but worked in law enforcement for 5 years in one agency, 5 in another, been in and out of law enforcement circles, and still connected right now as it relates to gangs. With that being said, I'm all about data, and I'm all about using metrics that are easy for you as students to follow. So you don't take my word for it, because it's not about my word. It's about what the data says, right? So when we look right here in 2020, There were 9,544 stops. 5,791 of those stops were innocent people. In other words, we just stopped somebody reasonably because we thought they were doing something. You could have just been walking down the street minding your business, but you were stopped and asked questions and you had to listen and comply, which we'll get to in a second. Look at the numbers, right? Of the people who were stopped, 56% were black, 30% were Hispanic, okay? Now, in terms of, in terms of the sheer volume of stops, that's 86% of the people who were stopped under stop and frisk. 86% were black or brown. Again, you don't need me to tell you. This is the data that was pulled. These were the numbers that were examined by ACLU and civil rights groups. In 2021, primarily because we were still in quarantine, although we were coming out, the numbers, dwindled a little bit. But still, you had 60% of the people stopped were black, 27% were Hispanic. So you're talking 87% of people who were stopped were people of color. So again, controversial tactics and measures that exist when it comes to police contact or police contact or disproportionate minority contact. And this was one of them, stop and frisk. Some people question, if I'm just a black man or a black woman or a Hispanic man or a Hispanic woman and I'm just walking down the street, I can be carrying a bag of groceries trying to get to my home, especially in New York City where it's densely populated. And you as a police officer can say, hey, excuse me, you need to come over here and answer questions. Sir, excuse me, I'm carrying groceries. I'm not sure what. No. If you don't come over here, we're going to get physical. You're resisting arrest. That's what it's all about. And that's why these methods are very controversial. And many say that they become problematic for certain people and certain groups of ethnicities. Seizure. So I know I gave you the Fifth Amendment, which protects you against self-incrimination. You complete the Fifth. We talked about the 14th Amendment, which gives you due process rights. But the Fourth Amendment is the one you need to be the most concerned with. Give or take. But it's still the one that is going to kind of stand out. The Fourth Amendment protects you against unreasonable searches and seizures of your person or property. If you get stopped by the police and the police are like, sir, I want to search your car, or ma'am, I want to search your car, you can say, excuse me, no. You can say, sir, ma'am, with all due respect, do you have a warrant to search my car? No, I don't have a warrant, but I have a reasonable suspicion. Now, let's articulate this, and I'm going to give it to you from a law enforcement perspective. If police go ahead and they come up to your car and they smell weed or they smell other narcotics or drugs, out the window. You can say, you can't search my car. No, they're going to search it because they smell something or they see something in plain view. We're going to get to those doctrines in just a minute. But if you're just minding your business, you're driving down the road, you're black, you got your music on, you're feeling good, you're grooving and jamming, it's the summertime, life is great, and then the police pull you over and they come up and they say, sir, I'd like to search your car, and you've given them no reasonable suspicion whatsoever. Maybe you were doing a little bit too fast. You're like, excuse me, sir, I was driving a little fast. I was having a good time. Just going home. You better know your Fourth Amendment rights. You better understand that they can't just unreasonably search your vehicle. And if you give them consent, you can't just give them consent and be like, oh, never mind, I'm taking it back. No, understand that you are protected under the Fourth Amendment. Okay? A lot of people don't understand that. In fact, we as citizens are afforded a level of privacy, and we have a reasonable expectation to privacy in our homes and in certain places. So the California versus Greenwood case, the California v. Greenwood case in 1988 ruled that no warrant was necessary to search trash. The reason why this is important is because while you could argue, the trash is still on my property, law enforcement snooping around my trash can on my property should be illegal, the state ruled, at that point, it's reasonably to assume and articulate that you've thrown out the trash. Therefore, it's no longer your property because eventually it's going to be property of the city of LA or the city of Compton or the city of Inglewood or the city of Sacramento, whatever. So that's why that case was noteworthy, because people tried to say, no, the trash can is on my property. The trash is still my property. It's not your property. It's essentially becomes the property of the city, because once they confiscate it, that is it. There's nothing more to decipher the trash being yours. So you can't argue that your Fourth Amendment rights were violated because you were throwing it out to begin with. So one of the things I want to say is, are canine searches reasonable in your opinion? Should they be allowed? And what are some of the instances where you think that a canine would be used to apprehend a suspect? Now, think about this. Can dogs sniff outside your home? The answer is the Florida court said no. Even though your trash under the California v. Greenwood case, it's okay for the trash to be seized and apprehended. When it comes to police dogs, on the other hand, because they are an extension of law enforcement, they are an extension of the police, the Florida court said no. It's absolutely considered an unreasonable search because we have a greater level of privacy in the home. So if the police are walking around your house with a police dog sniffing around without a warrant, no. Florida courts say no. Can the dog sniff your car? Yes, the dog can sniff your car. Now, certainly the credibility of the dog is going to come into question, because you can say how many positive alerts have the dog had, right? And remember, these police canines are very well trained dogs, but even so, they can sniff your car. Now, once again, if you get stopped and you say, no, I'm not consenting to a search, you have no reason to search my car, I'm not going to consent to a search, then what you need to understand and what you have to recognize is that from a law enforcement perspective, they're going to radio for a canine unit to come. And at that point, the canine unit is going to sniff around. Now, if the canine sniffs and gets a hit that you do have drugs in your car, then at that point, they're going to have a reasonable suspicion to search your car. You could still fight it in court, but generally speaking, you'll probably lose that battle at that point. You also have some angry officers because they're going to say, well, why didn't you just let us search your car to begin with? But truth be told, you have a right to keep your Fourth Amendment rights protected. So it's just a sticky situation all around. But generally speaking, if the dog sniffs your car and gets a search, they're going to ask you, okay, dog's got a hit. What you got in your car? And if you're like, I don't have nothing in my car, then they're going to go ahead and start searching, though. Okay? Now, the Supreme Court is tasked with determining the limits of search and seizures with police dogs. In most cases, the court has determined that canine sniffs are allowed under the Fourth Amendment. See, that's just what I talked about, right? So with a canine sniff, even though you said, no, you are not violating my Fourth Amendment rights, so I'm not consenting to a search, they're going to say, okay, sir, ma'am, step out of the car. Now, again, we're going to talk about if police give you a command, what are you supposed to do? We're going to get to that in a second. You better get out of the car and step out of the car. What's going to happen is you won't stand there on the side of the road, have your arms crossed. If you know you don't have anything in your car, you're going to be very upset. You're probably going to want to get badge names and police names, badges, and numbers, so that way you can start filing your lawsuit and complaint. But right now, if you have something in the car, you're going to be like, he's coming with a canine. And when that canine gets a hit, guess what? The Supreme Court's saying that dog sniffs are allowed under the Fourth Amendment. Once they get that hit, they're searching the car, and you can argue it in court. And I really want to underscore this point, especially if I have young people watching this who might have friends who have things on them. If you got a buddy in your car, a friend of yours in your car, and they have narcotics, number one, you better start talking to people and letting them know, do not bring that crap in my car. That's number one. Number two, if you get pulled over, even if you're the one driving and they have it in the car and law enforcement say, hey, I see a whole bunch of y'all in the car. Y'all want to step out? Anything illegal in this car? No. Okay. Can I search the car? No. Can I call my parents? Well, we're going to talk about that in a little bit as well. But even so, if a buddy of yours has some drugs or something they shouldn't have, if they drop that in your car and nobody takes ownership, everybody's getting charged. If they drop it in your car, the canine comes out and gets the hit and the scent, they're searching the car. Now, somebody better fess up or everybody's going down for that. I'm telling you, it's a very slippery and tricky slope when it comes to canines searching cars. So let's talk about warrants, right? So warrants, the Fourth Amendment will generally require a warrant before police can conduct a search. Now, there are some exceptions, right? First of all, the key to obtaining the warrant is probable cause. You have probable cause that a person is holed up in a house, probable cause that there's drugs or drugs or illegal narcotics, weapons, whatever, in a home. But the first key is probable cause. You have to establish probable cause. Most warrants are executed during the day. Police have to knock to identify themselves. So have you ever had the open up, police? Have you ever had that knock? I'm sure any of you that are watching this lecture probably haven't. And I've had some people be like, man, Officer Fields, you go knock like you the police, and that was back in the day. But, you give that commanding presence. You don't want to get that heavy knock. You don't want to hear, open up, it's the police, So understand that warrants are generally executed during the day and police will knock and identify themselves. Now, again, knock and announce warrants are commonly used. Getting that knock, that heavy knock. Police, open up. We got a warrant. You better comply. You can't just go ahead and be like, no, I'm not gonna comply. No, you have to. Where we start running into controversies are the next point, and that's the no-knock warrant. And the no-knock warrant allows law enforcement officers to enter the house forcibly without identifying themselves as law enforcement. Imagine you're in your home and it's the summertime or it's late in the fall, you're watching the game, you're just kicked back, you're propped back, you're having a nice cold beverage, you're enjoying yourself, and the next thing you know, bam, your door is kicked in and here's a whole group of people coming in. Now, if you are somebody that believes in your Second Amendment, because we talked about the Fifth, we talked about the 14th, and we certainly talked about the Fourth. We didn't talk about the Second Amendment because we don't really need to in this course, although a couple of chapters ago we could have when we were talking about firearms, right? If you are a believer of the Second Amendment and you live in a state where it is easy to obtain a firearm and you are having a firearm for your self-protection, then things are going to get dicey, right? No-knock warrants have been used at night, and according to my law enforcement circles in the area that I live in, Gwinnett County, which is a metro Atlanta suburb, they can be granted if the suspect was extremely dangerous or if there's a significant threat to the destruction of evidence or property. So, again, law enforcement sources here in Gwinnett County. I wasn't with the sheriff's office here, but I had a lot of buddies in law enforcement, some retired, some are still active. And like, hey, if you ever want me to talk to a class, I'd love to. I asked them about it because I said when I was in law enforcement, when I was with the sheriff's office in Florida, we didn't have no-knock warrants. In fact, I knew a buddy of mine that I went to church with who was in warrants. That was his unit. I was in Juvenile Relations Bureau. He was in warrants. There's a lot of different units. And I asked him, I said, hey, man, y'all do no-knock warrants? Just out of curiosity. He's like, nah, man, we don't do no-knock warrants. We are always going to knock and we're going to announce ourselves. In fact, that's just, our sheriff banned it. It prohibited it. Here in Metro Atlanta, especially as we are dealing with a major metropolitan area, no-knock warrants sometimes have been used at night. And again, if it's an extremely dangerous suspect or there's the belief or threat to destruction of evidence or property, that's when a no-knock warrant will be granted. But it's very controversial because if you've never heard of a no-knock warrant or you've believed that no-knock warrants have garnered national attention, all you have to do is look at this case right here. This is the case of Breonna Taylor. I don't have time to talk about Breonna Taylor, but what I would like you to do in your spare time is just go look up no-knock warrant Breonna Taylor, and see what happened there. So what are some exceptions to warrants? There's notable exceptions. For example, consent, the agreement that has to be made without coercion. So, hey, if you don't let me search this residence, I'm going to arrest you. You've actually coerced them, right? They hopefully will inform their lawyer, hey, sir, ma'am, or the judge, hey, sir, ma'am, your honor, they told me if I didn't let them search the residence, they were going to arrest me, and then they arrested me anyway. All you have to do is simply ask, hey, are you okay with me searching this place? You don't have to be stern like, hey, you better let me search this place. No. You say, hey, are you okay with me searching? No, I'm not okay with you searching. Okay. Are you okay with me searching your locker? Sure, it's nothing in there. You okay with searching me searching your backpack? Yeah, it's nothing in there. All right. And they start knifing through and searching through the backpack. Plain view. This is the one that I was very much privy to, especially back in my probation days. Plain view allows police to seize illegal materials or evidence without a warrant. If they enter a house and they see illegal contraband on the table, it could be on a dresser, it could be next to a bed. I mean, plain view, everything's out the window there. They don't even need a warrant for that. Exigent circumstances, emergency circumstances are narrowly defined by the court. So think about escape, think about harm to officers or others, think about a destruction of evidence. So if there's an exigent circumstance that somebody's going to go ahead and start flushing drugs down the toilet, you better get in there and get those drugs ASAP and do what you need to do to preserve evidence. So that's one. A couple other exceptions, incident to lawful arrest. A law enforcement officer can search someone. You can search someone without a warrant once you've lawfully arrested them. We're going to talk about lawful commands in just a moment, and all this is applicable to the law simply because if I'm placing you under arrest and I'm putting you in handcuffs, I have to ensure for my safety and yours that you don't have anything that could be damaging to you or me. That could be a weapon, it could be contraband, it could be anything. So if you're lawfully arrested, you will be searched. You've seen it in the movies and TV shows, the pat down, what's in your pocket, turning the pockets inside out, going through the pockets, checking between the legs and all that. And then they will ask, do you have anything else on you that I should know about? And if you say no and you get to that jail and you do, it's going to be a bad day for you. Very bad day for you. And that also includes the frisk of the suspect as well, frisking them, right? Automobiles and boats. Police have a probable cause to believe that the vehicle or vessel contains contraband, fruits of the crime. If so, then of course they can search the automobile and they can search the vessel. But again, there are exceptions there, right? Those are a notable exception if they have probable cause as well as a reasonable suspicion. But you can't just go searching stuff without being able to articulate probable cause. The best way to articulate probable cause is if you smelled something or you saw something, right? But just going through somebody's automobile just because you pulled them over and you were having a bad day or they mouthed off at you, it's not going to stand up in court. The suspicionless search is based on place and reasonable potential of wrongdoing, commonly found at airports, the border, public schools and courthouses. Then you have the emergency doctrine. Again, if there's a danger or destruction of evidence, if that's imminent, you'll have that. And then you even have your regulatory searches, such as, for example, government officials, health inspections of restaurants, vehicle crossing borders, fire inspections, airport screenings, parole and probation officers. We fell under that doctrine as well. We were absolutely able to search people. And if we found contraband, we can absolutely file charges, take them into custody, or request warrants, depending on the jurisdiction. So what does it mean when someone's under arrest? If a law enforcement officer says, ma'am, sir, you are under arrest, what this means is that they have lawfully detained you. It's a lawful detention of a suspect or perpetrator in which they're not free to leave the scene, either under a valid warrant or based on probable cause that a crime was committed. So if a law enforcement officer says you are under arrest, then there is a reasonable suspicion that you're taken into custody because of probable cause or because of a warrant. Now, the courts have been very unclear that if the words uttered, "you are under arrest," are they necessary and sufficient? That is still debatable. But what I'm here to tell you, based on a training that I went to a couple of years ago, and it was fascinating. I had notes, and I wish I had pulled the notes up. The individual from the GPSTC. GPSTC is the Georgia Public Safety Training Center. GPSTC. He had something so powerful. If you're putting somebody in handcuffs, you can't put someone in handcuffs because you need to make sure that you're safe and do it under the guise of you're detained. So I'm detaining you for now, but then, okay, you're no longer detained. I hate to say it, law enforcement does it all the time. And most of the time, they don't have people challenge them. He was very clear in the training. You can't just put someone in handcuffs for your safety under the guise that they may be under arrest, they might not be under arrest, but I'm just putting you in handcuffs because I'm not sure. No. You're either telling that person you're under arrest, so put your hands behind your back, I'm going to put you in cuffs and we'll have you sit over there. And then you might come back and say, okay, ma'am, sir, I apologize. You're no longer under arrest. We determined through probable cause you weren't the person we were looking for. You didn't commit the crime, whatever, and you freed him. Or you just tell him, hey, you need to have a seat over there. You're not under arrest right now, but you're also not free to leave the scene, which I'm going to get to in a moment, but you need to sit over there. Now, if the person starts resisting, then, okay, we got a little bit of a problem. But he was very clear. The instructor said, you can't put somebody in handcuffs under the guise of this is for my protection and your protection. And they're sitting there in handcuffs, wondering what's going on. And then you say, okay, everything's good. I'm taking these handcuffs off you. You're going to get yourself in a lot of trouble. Again, it's very important, and the public doesn't understand it. They just think, oh, law enforcement's throwing me in handcuffs because they got to sort out a scene. So I'm sitting here with cuffs, probably crying, probably feeling dejected. I wasn't told I was under arrest, but they're just saying this is for my safety and yours. You can't do that stuff. You can't. And I'm telling you, when he said it, I took notes and started, highlighted it, bolded, because people don't know that. They just assume I'm thrown in cuffs, so I must be under arrest, and you weren't even acknowledged that you're under arrest, or it wasn't shared to you that there was probable cause by law enforcement to place you under arrest. I'm telling you, I love talking about this subject because a lot of people don't understand it. And so when we look at these questions and we look at the idea of being arrested, a question that you have to pose: if law enforcement gives you a lawful command, are you obligated to listen and follow the command? Absolutely yes. If they tell you, sir, ma'am, I need you to have a seat over here while I sort this out, you better not say, excuse me, I'm leaving this place. Now you're getting yourself in trouble. Now you're about to get thrown in these handcuffs. Okay? So please do not do that, right? They're giving you a lawful command. You might not like that lawful command, but the law enforcement officer is trying to approach this subject in a manner that, hey, I'm not placing you in handcuffs because I'm not trying to do this illegal stuff that some people do. And I'm trying to determine if I even have any probable cause. But for right now, while I sort this out, please have a seat over there. Please stand over here. Please go over here while I sort this all out. They've given you a lawful command. You must follow it. You must obey it. Next question. When police give you instructions that you are under arrest and being detained, can you leave the scene or location? You should know the answer to it. Say it with me. No. When they give you a command that you're under arrest, you have to comply with the officer's request and you will be taken into custody. I love this topic too on police and the rule of law because I had a very great video that I played. It happened in Atlanta. A lot of Atlanta and Florida are the gifts that keep on giving when it comes to a lot of my courses, right? Because I worked in law enforcement in Florida and I worked in law enforcement in Georgia, and I'm from the Atlanta area, Metro Atlanta, but still. And in this particular video, and I was gonna, potentially include it in another forum, but this woman and a man were in a park. It was super late at night. You and I can probably guess what they were doing in the park. Police officer rolls up. It's like, you're trespassing. First guy gives his name. He's getting a ticket. All he has to do is pay the fine, $100 fine. And he was like, I got to sign this, right? And he was like, yeah, you got to sign it. And he's like, if I don't sign it, he's like, if you don't sign it, you're going to jail. And he's like, oh, okay, I'm going to sign it. Pay the ticket. You're good. The woman is mouthing off. She's going, oh, you can't do me like this. She gets arrested and she is having a meltdown. It is absolutely, it's like 15 minutes. And I've shown it in class. And students are dying laughing, but I'm proving the point that they told her if she didn't sign the ticket, she was going to be placed under arrest before trespassing. It's a clearly posted no trespassing sign in Atlanta. You're out there at, I think it was like 1 a.m. doing stuff, because we can assume what they were doing. And clearly she didn't want to comply. So if you don't comply with law enforcement's commands that you're under arrest, guess what? You're going to jail. You're taken into custody. You don't have a choice. And so last thing, when looking at Miranda, we talked about it. We talked about, again, remember the Miranda card, right? Remember I held up the Miranda card. We talked about it, and there was a landmark case. It was Miranda versus Arizona in 1966. And that case established the guidelines that have to be followed when informing the suspect of her or his rights. So in this particular case, now individuals have to understand that they have the right to remain silent. They have the right to have an attorney. Anything that they say can be used against them in a court of law. Do you understand these rights? Do you wish to speak to me after understanding these rights, etc.? There are some exceptions to Miranda. And again, we're not going to get into these cases per se, but what I want you to understand is that Miranda becomes very tricky when you get to juvenile suspects. And because I worked in the Juvenile Relations Bureau and a lot of my career was centered around juvenile offenders, it becomes very tricky with, does a 10, 11, 12, 13-year-old understand Miranda? Does a 10, 11, 12, 13-year-old understand that they do have the right to remain silent? Because how have we trained kids, folks? A lot of you that are watching my lectures, a lot of you are much younger, way younger than I am, half my age probably. And so with that being said, I want you to understand, how did your parents raise you when talking to police and law enforcement? They probably told you to tell the truth, right? Miranda gets very tricky when we're talking about juvenile offenders. So I want to thank you for this chapter. It's been a pleasure talking to you all about law enforcement in chapters 4, 5, and 6. And I tell you, it's a topic that in in-person intro classes, it takes about 3 weeks, but I could easily drag it out for 4 to 5 weeks because there's so much. But I try not to do too much because as an introduction to criminal justice course, I don't want to get too heavy into the topics because we can save those for more specialized courses. But within this chapter, looking at police and the rule of law, we did talk about those constitutional amendments. The Fifth Amendment protects you against self-incrimination. The 14th Amendment gives you due process. And even the Fourth Amendment protects you against unreasonable searches and seizures. But one of the takeaways is we talked about Miranda. Again, if you are stopped by police, if you are having to talk to police, you do have the right. You do have the right to remain silent. You do have the right to have an attorney. You do have the right to not talk to that police officer, even if they're asking you questions. You have those rights. So I want to thank you for tuning in on this first block as we looked at the first component, the first primary component of the criminal justice system, which is law enforcement. The next module and the next group that we're going to start talking about are the courts. Thank you so much for tuning in. Be sure to continue to like and subscribe, share with your friends, share with your family, share with your loved ones. If you feel that this is very educational and informative to you, it may be educational and informative to somebody else. Whether you're at a different college, a different university, live in a totally different state, you might be even somewhere on the other side of the world. If you want to learn about our criminal justice system in a way that may be a little bit entertaining and hopefully somewhat amusing to an extent, but certainly informative, then please continue to stay tuned and be sure to subscribe and check in. Thank you so much, and I will see you next time.